Thanks for joining me in part two of my analysis of some of the legal issues surrounding the shootings that took place. I believe it was on Tuesday in Kenosha, Wisconsin. The reason I feel it's necessary to devote really 2 days in a row of videos on this incident is because it goes to the core of my favorite phrase, and that is freedom is scary. This is the culmination of many different things that have been going on in our country. The fact that government leaders have been allowing violent rioters or protesters to destroy private property, to kill people in some circumstances, and to cause general mayhem in a lot of these cities. And the police, and whether instructed to or not, in many of these areas have allowed it to happen. Some of them have taken a knee. Some of them have been instructed to stand down. And this is really something new in our country, and it's been coming for a long time. And it's happening for political reasons. Oh, it's okay, Helga. I'm starting to get loud, and I scared my fearless guard dog, my German Shepherd, Helga. She doesn't like it when I raise my voice. But this has been coming to a head for a long time. So we have the government doing everything but what they're actually supposed to do, their core function, and that is to protect their citizens, the people within their jurisdiction. I mean, that's really the only thing they're supposed to do in many instances. But they've made, for whatever political reason, a conscious choice in a lot of these cases to completely fail in that task and to let people destroy businesses, to destroy homes, to go into private neighborhoods and completely harass people. And whether you agree with their political objectives or the underlying reasons in which they say that they're doing that, it doesn't really matter, because at the point at which you begin to trample onto the rights of your fellow citizen, something needs to be done. So either the government protects you, your life and your property, or the government allows you to do so. Not that they should be allowed to let you to do so, but we know that there's 5,000 plus federal laws on the book. And there was only about a dozen to a dozen and a half federal laws in 1791 when our Constitution was ratified. Now we have 5,000 plus, because politicians only go forwards. They don't go backwards, unfortunately. They don't voluntarily decrease the size of the government at any level. So we have books full of criminal laws, but government leaders who, at this point, for political reasons or because of cowardice, are not defending people's lives and their property here in 2020. So therefore, what's going to happen? Something is going to have to fill that void, because there's not just going to be a vacuum where rioters will burn up and destroy wherever they go in the country and there's no response. So if they're not going to defend life and property in these cities, it brings up a lot of questions. And that is, well, what are your rights, and what are the rights of law-abiding citizens and property owners when it comes to these violent rioters or protesters? At the same time, we're kind of also getting at the culmination of the legal challenges around the AR-15 style rifle. And it just so happens that was what was used in the Kenosha shootings. So are AR-15 style rifles treated differently under the law? And it really does go to the heart of the concept of freedom is scary, because what do they call the AR-15 style rifle? They call it the black rifle. And a lot of times we refer to it as the scary black rifle, facetiously, because a lot of the Karens of the world, they see an AR-15 style rifle and they're scared. And they expect us to give up our rights to possess or to use an AR-15 style rifle because it scares them. So freedom is scary. So these are some of the questions really that I think are posed here that I haven't already discussed. And one is, and this is an interesting one, and I'll talk about first, is can you unlawfully possess a firearm and then lawfully use that firearm in a self-defense situation? Secondly, can you and should you be able to defend private property using deadly force, using firearms? And if not, can that law be changed in your state? Were there new information releases today that are relevant to whether or not the self-defense claim of Kyle Rittenhouse it has any validity? Does the mention of militia in the Second Amendment have any applicability today? I've seen where people have brought up, if the Second Amendment discusses militia, he was supposedly there as part of some quasi-militia. Does that have any legal ramifications or really any legal relevance at all? And lastly, where is Wisconsin within the context of federal law? What circuit are they in? And what's the law? What are the federal Second Amendment cases out of that circuit? And do they have any effect on what happened? What are they, what is their circuit's feelings towards AR-15 style rifles? Have there been any decisions in their circuit that might give us a hint as to, the federal lay of the law of the land, and that's going to apply in Wisconsin. So those are the kind of the things I didn't get to last time that I wanted to go through. Get questions already. Protect citizens and enforce contracts between individuals. I got 99 problems, but law ain't one. All right. All gun laws are an infringement. That's true. The Second Amendment says, shall make no law, though it does say Congress. But to be fair, the states were made up of armed citizens who were required to be in the militia, and we weren't going to join a confederation of other states and create this national standing army, this national power that would be able to disarm the citizens. So that's the way it was worded in that way as well. But let me get to the first issue, and then if I have time, I'll go back to some of the questions and comments. So I think it's an interesting issue, unlawful possession of a firearm in a self-defense situation. And this is really kind of one of those law school questions that are interesting. It's one of the things that I liked about law school is that you would just come up with these different scenarios and try to apply the law that exists to all these scenarios that you could think of. So who would have thought this scenario up, when I had gone to law school? But so what people have brought up is, all right, the kid was 17, and under Wisconsin law, he wasn't old enough to possess a firearm on his own. He was only 17. One year older, or perhaps a few months, I don't know when his birthday was, he would have been completely legal to possess the item that he was possessing where he was possessing it. Okay, so he's 17. Does that completely destroy his claim of self-defense? So he was breaking the law by possessing a firearm at the age of 17. Is he still allowed to claim self-defense? And I think that question, in my opinion anyways, and I'm not a Wisconsin attorney, and I'm not giving legal advice applicable to Wisconsin. I'm a West Virginia attorney, but I have thought about this topic, and a lot of these laws are state specific. But so I'm speaking in generalities here. But it's an interesting question no matter what state that you're in. And I think it's best answered with an analogy. So, well, let me give this example. Here's a couple examples because I've thought about this personally. All right, 5 or 6 years ago, I went to downtown Baltimore with my wife and with my kids and with my father. When I was a child, I had memories of, and I grew up in Florida, but I remember traveling up to the Inner Harbor in downtown Baltimore as a kid to go to this antique gun show. They used to have really the world's greatest antique gun show in Baltimore, and I believe it was at the old Armory downtown. And we would stay in a hotel right across from the Inner Harbor, and we'd go to this antique gun show. And they still have this antique gun show, but I'll tell you where it is now if you don't know. Anyways, then it was downtown, and we would go across the street and visit the USS Constellation and visit the World War II submarine that's sitting there. And those were just great memories for me. So 5 or 6 years ago, we had this antique gun that was in a display that the guy doing the display was going to set it up at the Baltimore Gun Show. Now, they had since moved it from downtown when I was a kid that we attended to the Timonium Fairgrounds, which is in basically a suburb of Baltimore. And they had to move it from what I was told years ago because it was just too dangerous to keep having downtown. That basically there were attendees to this gun show getting robbed at gunpoint and carjackings and so on. Which if you've been to Baltimore, apparently is not that unusual these days. So now it's at Timonium, but nevertheless, I wanted to stay downtown to kind of relive those memories that I had when I was a kid of, going across to the Inner Harbor and visiting the Constellation, which is awesome, and going to the submarine. And also Fort McHenry is there as well. So there's a lot of cool historical stuff in Baltimore. But I'll tell you what, when we went to Baltimore, it really wasn't at all as I had remembered it when I was a kid. It was extremely dangerous. And, we weren't there 10 minutes before my wife got assaulted by, a group of inner city youth within 20 feet of our hotel. And this was a $400 a night hotel, and basically you weren't safe anywhere. Somebody pulled the fire alarm within minutes of myself and my father leaving to go to the gun show. And my wife's in the shower, and my son, he was young, really young men. And he comes in and says, Mommy, we have to get out. And I was really proud of him. He gathered up his mother and his baby sister, and he got them out of the building because the fire alarm was going off. But it wasn't legitimate, and it was just really bizarre, and it was a false alarm. And we had all these really kind of scary instances. And of course, I was completely disarmed the entire time I was there. Even though I was a West Virginia resident with a West Virginia concealed weapons permit, I could not carry in the communist state of Maryland. I was not allowed to carry lawfully a concealed pistol of any sort. So that meant that I had to be completely disarmed. And I, of course, being a lawyer, followed the letter of the law. And I went there, with no means of really defending myself. And of course, I have no confidence that any of the criminal elements who were there also followed the law. But at one point, it really, really got pretty froggy. There's not an air bridge, not a covered bridge either. It's a bridge that goes over like the 6-lane road that goes between the hotel and the Inner Harbor. And as we were crossing that, basically we got surrounded by this group of they looked like gang members for sure. And they were definitely up to no good. And they just stood there and blocked our way. Then they appeared at the other end of the tunnel and I really thought that we were about to get robbed at gunpoint or whatever was going to go down. And I never felt so helpless in my life, being completely disarmed. And, I said to myself, and it's the case now, that if I'll never go voluntarily probably back to Baltimore, but if I ever go again, I really don't give a damn if I'm breaking the law. I'm taking a concealed pistol with me. It's just the way it is. I'd take my chance at eating a misdemeanor in Baltimore for illegal possession of a firearm, which hopefully I would assume that's a misdemeanor. It usually is, rather than taking mine or especially my family's lives in my hands by taking them back to Baltimore like that, or at least in the Inner Harbor area. So I would rather violate the law and carry unlawfully. Now, let's just say that I did that. So let's say it's a criminal misdemeanor to have a concealed pistol in Baltimore, or where I'm not allowed to have it, and I'm violating that criminal misdemeanor in Baltimore, in the state of Maryland. So I'm committing a misdemeanor. But what happens if I do get robbed at gunpoint, or a group of armed men is trying to kidnap my wife? So what are my rights then if I have this illegal pistol? Do I then not use it in her defense, in defense of her life, or in defense of my son's life, or in defense of my life, because I'm carrying unlawfully? Does that mean that I can't claim self-defense or defense of others? Does that mean if I shoot the guy who's trying to kidnap my wife or trying to kill her, does that make me a murderer because I had an unlawful pistol? No, I don't think it is. Absolutely, I don't think so. So, I think the law of self-defense is the law of self-defense. So this kid, if he was 17 and a few months later he's allowed to legally possess that AR-15 style rifle, does that mean that if he uses that rifle in self-defense, if he missed it by a couple months and he's committing a misdemeanor under Wisconsin statutes, does that mean that self-defense, since he used a firearm that he was possessing illegally, does that make him now a murderer? And again, I'm not a Wisconsin lawyer, but absolutely not. I don't think so. And, the right of self-defense always goes back to our English common law tradition. And it's a common law self-defense. And, our founding fathers noted that we had natural inalienable rights. The right to life is the right of self-defense. So I think it's best to look at it this way when it comes to the unlawful possession, potentially, of his firearm. Number one, he's on private property. And I think that's an interesting issue here, is he was supposedly there protecting this car dealership. Well, some of the questions I have are, did the actual property owner know that he was there and ask for him to be there or to protect that property? Or did they ask this group that he was with and they just delegated that task to Kyle? I don't know the answer to that question. But I think it's important to know, he was on private property. If you look at the first video with the first shooting, he's running across, I believe that is the car dealership that he's running across. And so he was on private property. The rioters came onto that property and started damaging the cars. And I don't know if there's any video that shows the very beginning of that. But so he's on private property. And let's assume that he does have the consent of the property owner. And let's assume, thirdly, that he's in possession of a legally owned or legally possessed firearm that is legal in that state, which he otherwise would have, presumably just within a few months. or maybe a close to a year at the most. So the first encounter shows him being chased and then having something thrown at him on that private property, that car lot, which he was attempting to protect. So let's change the facts up just a little bit. Would it be any different if this kid Kyle was the son of the owner of this car lot? Would that make a difference? Let's not even make it a car lot. Let's say this is a residence. What if this is a home? And I think this is where it's really, going to hit home and apply to a lot of us, especially in rural America or even suburban America, is what if it's not a car lot? What if it's a home? What if it's a residence? And what if this is the son of the owner of that residence? Let's change the age. What if this is a 14-year-old instead of a 17-year-old? A 14-year-old who lives at that house with his parents. The family has an AR-15 or more, and the kid has been trained by his father how to use it, knows how to use it. He perceives a threat. There's somebody threatening their lives, breaking in the house, armed or unarmed. Could be baseball bats. The 14-year-old kid perceives a threat. He grabs his father's AR-15. Again, he's not 17 yet. He's 15, still in Wisconsin. And he uses that AR-15, which his father has taught him to do, and he shoots the armed intruder, the burglar, and he shoots and kills them. Now, it's my understanding that in Wisconsin, there is no castle doctrine. There is no stand your ground law. So therefore, there is a duty to retreat under circumstances in Wisconsin. I think that's going to apply to Kyle Rittenhouse. But imagine the scenario where a 14-year-old who is not old enough yet to own or possess a firearm under Wisconsin law grabs an AR-15 and shoots an armed intruder. That's still going to be a self-defense analysis. And is the fact that the kid is 14 going to automatically make him guilty of murder instead of going through that self-defense analysis? No way. So I think you can change the facts around, but no matter how much the media tries to make it sound like this kid was in violation of the law and therefore can't claim self-defense is absurd. So facts will always matter. And as I've told clients before, and I pretty much usually tell all my clients, when we start talking about the facts and testifying, is what? No case is the perfect case. They don't let lawyers make up their own cases. Therefore, when you're dealing with reality, you have to deal with what you're given. Every case has its good points and every case has its bad points. And you can't try to pretend that the bad points don't exist. You have to be prepared. And it's a little different in criminal cases. In civil cases, you have to pretty much answer every question. You have to discuss everything. Criminal cases, you don't have to testify. Always. I mean, you never have to testify. You have a right not to testify, but sometimes really there's no other option. But in any event, even from a strategic legal defense standpoint, every case has its bad points. No case is perfect. But the worst thing that you can do is to harm your credibility, to get caught lying. That's the one thing. See, bad facts will usually never alone destroy your case or destroy your defense, but lying will. And you get caught lying, you hurt your credibility, then you've 9 times out of 10 destroyed your case. Because in the end, you're dealing with jurors. And jurors, I mean, you lie to them, you lie to them once, you're done. You get caught lying, and it's all they'll hear. That's all they'll hear. So credibility is the most important thing. There's another analogy I thought of that really is good for debunking this narrative that an unlawfully possessed gun, even if true, is somehow negates the laws of self-defense. So picture this. Let's see, you're 17 years old and you're flying on an airliner. So you're 30,000 feet in the air. You're halfway to your destination. A terrorist stands up and shouts, Allah Akbar, Allahu Akbar. He pulls out a knife he had shoved up between his legs. He runs towards the closest passenger and he goes to cut her throat. Suddenly, an air marshal pops up. He pulls his pistol that he had hidden. He had it concealed, and he goes to shoot the terrorist. But the terrorist runs at him, and he lunges, and then they get into a struggle. And the terrorist is going for the pistol, and they're struggling. And as they struggle, the pistol flies out of their hands, and it lands at the feet of this 17-year-old you on this airliner. So there's a terrorist with a knife and a disarmed air marshal struggling for their lives on an airliner at 30,000 feet. The pistol falls at your feet. You're only 17 years old. You know how to operate the pistol. Say it's a Glock. Your parents have a Glock. You've used a Glock many times. You even know that it's a Glock 19, and you know that's 9mm. And you know that the difference between a Glock 19 and a Glock 17. So you're familiar with it, even though you're under the age of 18. You technically can pick up the pistol. You have a clear shot at the terrorist. Clearly, you're in fear of your life. You're in fear of the air marshal's life. You're in fear of the life of everybody on the airliner. If you pick up that pistol, is it murder if you shoot and kill the terrorist just because you're only 17 or because you're on an airplane? No, of course not. Even though it's technically a felony, a federal felony, to be in possession of a firearm on an airplane. Under the circumstances, that's not going to negate your self-defense analysis. If you do pick up that pistol and you shoot the terrorist, and some rogue prosecutor wants to charge you with murder, you'd have a great affirmative defense to that, because it would be a justifiable homicide, a justifiable shooting, because you were in the fear of your life, the air marshal's life, and everybody else on the plane. Even though you're underage, even though you're on an airplane, it doesn't matter whether you were violating any law of possession of a firearm to pick it up and use it. So those are two separate things, and I think absurd analogies are a good way to point out, to illustrate that those are two separate issues. Whether or not it was unlawful possession of a firearm doesn't necessarily affect whether or not it was an unlawful use of force in self-defense when the shootings occurred. And as I understand it, there was information that was released today from the lawyer, I think it's Lynn Wood, that the AR-15 style rifle actually was a friend's, and that it had never crossed state lines. It was always in Wisconsin, and apparently it was lent to him by a friend. So what are the legalities of that in Wisconsin? Can a friend who is authorized to, who is legally allowed to possess this rifle in Wisconsin, can he loan it to an underage friend from out of state? I really don't know. And the point is, for me, is that it really doesn't matter. Let's see, lots of comments here. All right, Doug Lilly saying self-defense was not authorized because he was 17 with an AR makes as much sense as saying you can't move a disabled car off the railroad tracks because you're not 16. Exactly, and I think that's exactly the point, is how you defeat these narratives which there's always a narrative. The media, there's always an agenda, and the narrative will serve the agenda. And the media has an agenda generally here, and the prosecutors will have an agenda, and the media will push their narrative. They'll push their agenda. And so the best way to counter it, and I bet you that's what happens at trial too, because this is going to come up at trial. They're going to try to get the fact, if it was an illegal possession of a firearm, and it doesn't affect because it doesn't affect the ability to claim self-defense, they'll still try to get it to the jury, to bias, to prejudice the defendant in the eyes of the jurors. And then the defense lawyers will have to, through motions before trial, these are called motions in limine, to try to settle that issue before you get there, to get the judge to stop the prosecutors from even bringing this up. So, that's one of the strategic things that you deal with trying cases, is trying to, ahead of time, foresee the issues that will pop up. And if there's something that hurts you that you can get kept away from the jury, you want to do that, and you want to do it before the trial. And somebody else asked, Henry, jury trial versus bench trial in this case. I think absolutely jury trial. Maybe the only possible scenario under which I would want a bench trial might be, like the George Floyd case, that Derek Chauvin or whatever his name is. I think any jury that he gets there, arguably, is going to be biased against him. I mean, it's going to be really impossible to get a fair trial. I think that is one of the rare circumstances where you, as the lawyer, would be like, look, we should consider having a bench trial here. And that would depend, of course, on who the judge is, because then you have something else to go off of. But that would be an extremely rare circumstance. I almost would never give up a jury trial for a bench trial. And generally judges, and usually you're talking about state court judges in these sorts of cases. Judges, a lot of times, are elected politicians, like prosecutors. And a lot of times, in a lot of jurisdictions, they're really one and the same, because a lot of these judges, they probably, she was prosecutor before he or she was the judge. And they work together, and it's an entire big conviction machine. You can't depend on a judge really for anything in a self-defense trial or a murder trial, because you'll be highly disappointed. It comes to a shock, as a lot of people, and I've heard this before, is, well, why does the judge rule against us on absolutely everything? Everything we ask for, the judge denies it. Everything the prosecution asks for, the judge gives it to him. Well, welcome to the world of criminal defense. That's the way it goes. You don't get anything you want. The prosecution gets everything they want. And it all comes down to this, is that the only right that you ever have as a criminal defendant, well, you want to avoid being a criminal defendant, but the only right that you have once you get into that conviction machine is to pick a good lawyer and think carefully about who is going to stand up and speak for you, to be your voice. Because the only right that you have is to stand before those 12 jurors. Have your lawyer stand up before those 12 jurors and really to convince them that you're innocent. Because to get a not guilty, in most states, you have 12 jurors in a felony criminal case. You have to get all 12 to unanimously vote not guilty. So that's 12, all 12 people. You don't know who they are ahead of time when you're preparing. Sometimes you don't have a great choice. You might have to pick between a bad juror and a worse juror. In some areas, you get more options. I've had jury trials where I had a courtroom with 300 people in it to choose from. I've had jury trials where I've had 22 people to choose from. So it depends where you are. It's highly jurisdictionally dependent, but that's what it all comes down to. It all boils down to preparing to present a case to 12 people. You don't know who they are. So you're trying to think of the broadest sort of cross section, that things, how things might appeal to certain people. And you always have to play it safe if you're fighting for your life, because most times you don't get a second chance. Yeah, it's hope. Henry Henderson, I see your comment there. It's hopeless for most people without money. And that is really the sad truth. You want to talk about systematic injustice. Now, I'm not saying our system, that there's any better way of doing it, is because I don't know if there's any perfect way of doing it. Our founding fathers knew that a jury of your peers is the best way to protect your liberty, and they enshrine that into our system of government. And I agree that it is the best way of doing it. But having money to defend yourself, like everything else, it's going to make a lot of difference. Because if you have a public defender or a court-appointed lawyer, depending on where you are, you might get a really awesome lawyer, or you might get a really crappy lawyer. It's like in My Cousin Vinny, the lawyer that the guy gets, the court-appointed lawyer that stutters. He knows he's screwed, right? When he thinks his lawyer's great, he's been talking to him, and then he stands up, and the guy, he can't get the second word out of his mouth. Or there's that other meme I've seen floating around, and it just shows a guy's legs and his shoes, and it says, if your lawyer dresses like this, you're going to prison. And the pants are like too long, and the shoes are dirty, and it's funny because it's true. And there are those lawyers out there, and we've all encountered them. And a lot of times they look like hell when they come to court. And I mean, if that's who you're depending on to stand up and convince those 12 people, you may just be going to prison. So you get what you pay for. I've said that so many times. You get what you pay for. And if you want justice in our system, you better have some money. You might get lucky and not need it, but you better have some money. And you better pay all of it, because the way to win is to leave no stone unturned. That's the way to do it. Leave no stone unturned. Talk to every witness, and every witness that witness knows. I mean, you talk to anybody and everybody. That's the way to win. You never know when you find that additional witness. One time I had a case like this, and the family came to me and they said, do whatever it takes. We'll pay whatever it takes. And I said, well, if you really want me to, if I'm going to do whatever it takes, I'll set aside everything on my calendar. I'll take everything off. I'll do this all day, every day. They said, okay. So I did. And it took me doing that till I got to the day before trial. Finally, the hard work paid off. I found a witness who had seen basically somebody else commit the crime, and he had told the cops about it. And it never got to the defense. And so when I heard about this, I was like, oh. And so I changed my witness list to call an emergency witness, and the prosecutor fought me on it. And I said, well, Your Honor, this is reasonable. I just found out about it. It's exculpatory evidence. So the prosecutor or the judge excused it and let this new witness in. And this guy came in. Really, maybe it was during the trial. And then he testified in front of the jury, basically said that he saw somebody else do it. And then he had told the police about it. And I guess they just didn't tell the defense. And so that blew it up. I mean, it blew things up. And what were they going to do at that point? And to make a long story short, that one phone call caused the jury to come back, and it was probably 4 minutes, the fastest result I've ever had. Jury came back in 4 minutes with a not guilty. And I have no doubt that it was only because that family could afford to pay me to absolutely talk to every single person who possibly could know anything. And it wouldn't have had to be me. It could have been an investigator or something. But if you can spend money on defense, which this kid is going to have, he's going to have a great defense. And that is the one good thing for him, because he's going to have the best possible chance at persuading those 12 people to go not guilty on him. And that's what it's going to take. See, if 11 come back not guilty, and then there's one guilty, all it takes is one, you got a hung jury. So if you have a hung jury, the prosecution gets to start over and try again. And they could do that indefinitely. So it's never over until you get all 12 to vote not guilty. And that takes, it takes a damn good lawyer. It really does. And it's a heavy burden on a lawyer. It really is. And it's why I like civil rights cases, civil cases where we're arguing about money. I lose, we get no money. That allows you to sleep at night. When you lose and the person loses their liberty and they go to they go to prison, that is a heavy burden to bear. And it really makes it more difficult, makes it more stressful, and it wears on you. So money wins murder cases, but so does evidence, and most importantly, the right jury. Case in point, Simpson. That's true. Well, what did money get Simpson? Money got him good lawyers, but he also got really lucky. Hung jury, does the same jury sit again, Henry? No. Hung jury, they start over. Hung jury, here's how it works. And again, these are state laws, so it could be different state to state. But if you have a hung jury, the judge will make them, well, you guys continue to deliberate. I'm urging you to deliberate. And so the judge is trying to get the other 11 or the other 10, whatever the case may be, to convince the holdouts to go guilty or to go not guilty. But if they don't, then the judge has to declare a hung jury. And what happens is they basically just start over. The judge will have to schedule another trial. And so what will happen is they'll get another whole jury pool and pick another whole jury. So it will not be the same jury. It basically just starts all over. But then what effect does that, who does that benefit? Well, it could benefit both sides technically, depending on what kind of case it was. But generally, it's gonna benefit the prosecution, because as a defendant, a lot of times you're allowed to kind of hold your hand close to you. Sometimes you don't have to disclose all your dirty little secrets. You might have a dirty little secret that, a surprise witness, surprise testimony, because you can't take depositions in criminal cases. So nobody knows if the defendant's going to testify. No one knows ahead of time what he's going to say. So that's all going to be a surprise that the prosecution's going to have to handle as it happens. So they're going to hear his testimony and boom, they're going to have to cross-examine him right there. So they didn't know what he was going to say. They weren't able to prepare for it. So once you have a hung jury, now there was a court reporter sitting there the entire time. So now they'll have a nice little printout, a nice booklet with page numbers, and every line, every sentence is going to have its own number. So just like a deposition transcript. So now if the defendant's going to testify, they have a little booklet, the prosecutors do, sitting on their desk with the entire prior testimony of the defendant and every other witness who testified at the first trial. So now they know what they're going to say. And if they say something even a little bit different, they can impeach them and right in front of the jury. And they can use that transcript to show that their testimony has changed. So therefore, they can hold them to that transcript. They can prepare a defense to exactly what they were going to say. So they can have rebuttal witnesses essentially ready. So that a lot of times when there is a mistrial or there is a hung jury, they get them the second go around or even the third go around because they're ready for it. There's no more of these dirty little secrets. Now, sometimes it goes the other way. Sometimes the defense gets better. Sometimes they see now what the prosecution's strengths were, and they can make up for the deficiencies, or maybe they get a better lawyer. You never know. But generally, in my opinion, that is really going to help the prosecutor. So the hung jury, yeah, you do it again. And, it would be nice to make it a little easier. Like either the prosecution proves its case and they get a unanimous guilty, or else boom, in my opinion, it'd be nice to have an acquittal with a less than unanimous jury. But these are creatures of state law, so it could be different in each state, and that's up to the state legislatures. And that's our system of government as well, is deference to the states to decide what their laws are going to be. And that brings me to my second point, is the deadly proposed legislation that I want to discuss, and deadly force in protecting property. So in case you don't know, the general law in America is that you cannot use deadly force, which firearms are. You cannot generally use firearms to protect property, whether it's your home, whether it's your car lot, whatever the case may be. Now, there is at least one exception to this, and that is Texas, which has a statute that says that you can defend your property with deadly force at night, I believe. Don't quote me on that, and certainly don't shoot anybody over that, because I've never even been to Texas, really, outside of airports. I know nothing about Texas law other than that. I'm not a Texas lawyer. I'm just speaking in generalities, is that really Texas, to my knowledge, is the only place that really you can shoot somebody who's, for instance, outside your house at night in your driveway, breaking into your car or stealing your weed whacker. And really everywhere else in the country, you're only allowed to use deadly force to protect life, your life or the life of some other individual. So that's the default law. And the big example that they give you in law school is, all right, you are a power company, you're an electric company, and you don't need to leave this electric line live. The question is why not just leave it live so that one of these junkies doesn't come and steal the wire? They want to steal the copper wire. Just leave the thing live. That way, if they try to steal the wire, they'll touch it and they'll get electrocuted to death. So you're not allowed to do that, is what they teach you, because that is kind of like setting a trap. It's you have no legitimate reason to have the electricity on. You're just leaving it on to protect that copper wire. And the law is that you're not allowed to use deadly force. You're not allowed to kill people to protect the property. Therefore, that I don't remember what the case was. It was some old case, but that's the principle. That's what's stuck in my head, is you're not allowed to use deadly force to protect property, except supposedly this law in Texas, and that applies at night. But again, these are all creatures of statute. All these Wisconsin laws having to do with self-defense, all these Castle Doctrine laws, the stand your ground laws, all this stuff is self-defense. I'm sorry. All this stuff is state statute level stuff. So generally, the laws of self-defense are going to vary as per state, and it's the state legislatures that decide, what the criminal laws are, what the defenses to the laws are. So generally, as per state law created by state legislatures, there's no lawful use of deadly force in defense of private property. But if that's state law governed by state legislatures, that can be changed by statute, as it was in Texas. So especially for those red states out there, if your state, I mean, this has never really happened before, where government leaders have decided that we're no longer going to protect your private property. We're just going to let the rioters torch your car lots. We're going to let them, torch your homes, do whatever they want, because we're too we're cowards. So if that's the case, then why not lobby your legislators to change the law? This is an unprecedented year, 2020. We're told that we're in a new normal. Well, there's been a trend of legislatures across the state liberalizing gun laws, liberalizing gun rights, because the courts haven't wanted to liberalize the gun rights. They're still trying to be strict with gun laws. But legislatures across the country have amended their constitutions. They have enacted constitutional carry, such as we have in West Virginia. They've legalized open carry. They've legalized or liberalized concealed carry, and they've made it so I have a concealed weapons permit in West Virginia, and I can go pretty much from here to Florida and get reciprocity in every state, or I can go to Kentucky and get reciprocity. I can go certainly any of the states out west and get reciprocity. I just can't go that direction, towards New England. I can't go into Maryland, but pretty much any direction, at least for a while, I can go and I can get reciprocity, because these states, the legislatures, the attorney generals, they're all about liberalizing gun rights because that's what the people want. And so that's the trajectory that we've been going down. So isn't this just the next possible step? And we should get our legislatures, even especially in red states, such as West Virginia, that have really been coming out with great statutes. And as far as gun rights goes, let's enact a statute where our legislature announces and makes it the law of the land that we can use deadly force in defense of property. So no longer are we going to follow the common law, which we don't have to follow, that you can only defend life with deadly force. If our natural inalienable rights are to life, liberty, and property, certainly our property is important. So if we're allowed to defend our property with deadly force, that's a game changer in 2020. Because as it is right now, and a lot of people are surprised to know this, including in West Virginia, if somebody's breaking into your car at night, some freaking junkies out there bashing your window in, you can't just go shoot them, because although they deserve it, deadly force is illegal in defense of your car. Now, say you go down there and they attack you and then you shoot them. Well, that's why you get a lawyer, because that's the better scenario, because that would be in defense of your life. That's a different defense, and that's a better defense. But what if it were the law that you could shoot somebody that is on your property trying to destroy it and steal things and harm your property or your business? So how would that change things? I mean, we can see how it changed things in Kenosha, Wisconsin. Hell, there was one 17-year-old with one rifle. He didn't even have any extra magazines on him. He didn't even have any friends with him. And he stopped the entire thing by himself. After he shot 3 people, basically they were peaceful. They were completely quiet and peaceful protesters after that. I didn't hear anything about businesses being torched and cars being bashed. Basically, he stopped the entire thing. Can you imagine if all property owners were allowed to use AR-15s to defend their property? I mean, you would not have these Antifa types and their skateboards coming and setting fire to your business. It wouldn't happen. I mean, all you'd have to do is have a 17-year-old with an AR-15 or an 18-year-old with an AR-15 there sitting on the roof. And that problem is over. And all it would take is your legislature passing some sort of a statute. Hell, you know what? You could call it Kyle's Law. And although he wasn't defending property in the shootings that actually occurred, that's what he started out doing that night, was defending property. And that's another narrative that the media and the left is going to run with, is that they're going to claim he was defending property with deadly force with an AR-15. But no, we always have to go back to the fact that, you know, a person is allowed to open carry in Wisconsin. AR-15s are legal in Wisconsin. AR-15s are therefore legal to open carry in Wisconsin. So it doesn't matter that he had the AR-15. He's just a person. Once he's attacked, he's allowed to use self-defense. So just because he showed up with an AR-15 didn't mean that he had wanted to use it or intended to use it. The self-defense analysis means that you use whatever tools you have at your disposal. If you come prepared, then you might have more tools than somebody else has. So you don't let them drive your narrative. Self-defense is self-defense. As far as the tool that you use, it's if it's a legal tool to use and it was at your disposal, then that was lawful. So proposed legislation, why not have your legislature or lobby your legislature to make it legal? And I've been saying this for a long time. Why not just make it legal to defend property? And it's a problem in West Virginia. It's a problem everywhere with the drug addicts. You know, they would stop. Drug addicts would stop breaking into your property and stealing stuff. The rioters sure as hell wouldn't screw with you. I guarantee you. If you're allowed to defend your property with deadly force. How many problems is that going to solve? Who would be against that legislation that wouldn't already be against any legislation? So that is a win-win. If the police, if the government leaders aren't going to protect us, protect our property, we should be allowed to do it ourselves. And that is the history of our country. And you know, stronger, that's what these stand your ground laws, the Castle Doctrine laws, that's what they are, is a legislative correction to the deficiencies in the old common law. So with the common law, you had a duty to retreat, and that's basically still how it is in Wisconsin. And fortunately for the kid, it looks like in the videos, he's using every possible effort to get the hell out of there. But under the common law, that's what the law was, is you had to retreat if you could. So the stand your ground laws and the Castle Doctrine laws are basically, you know, getting rid of that common law duty to retreat. So you don't have to retreat. So you can stand there and yeah, you could get away if you wanted to, but you don't have to. If they're going to continue to attack you, then you can use self-defense. And the fact that you didn't retreat when you had the opportunity doesn't foreclose you from using self-defense. So I think some sort of legislation making deadly force allowable and defending your property, and including business property, I think that's a win-win. That's the next step from the stand your ground laws and the Castle Doctrine laws, and it makes sense from an economic standpoint. And you know, they want to. Hey, I would pitch it like this: they want to defund the police. That's what we're doing. You could even call it that's a good idea. The defund the police law. That's what you call it. And a lot of the idiots they may not even read it. They might not know the difference. So you call it the defund the police law. And what it means is basically is by being authorized to use deadly force to protect your property, then, you know, the police, they're not really necessary. Like you can hire less police and you're defunding them. So, you know, it makes sense. You don't need police as much. You know, we're gonna cut down on the police pensions and give people more authority to act in their own defense. Hey, it's a win-win, and they may not. You may get it through, and they don't even know the difference. Going to some new revelations today that came out in the Rittenhouse cases. I worked, I was swamped today, and I went back to back. A couple times I got to look at some things during lunch, for instance, of some new stuff that came out in the Rittenhouse case. A couple of things I didn't know yesterday because they didn't come out till today. One of the things is that, the attorney who represented Nick Sandmann, Lynn Wood, is now pro bono representing Kyle Rittenhouse, or he's one of the attorneys. I mean, I think you probably have to have local criminal defense attorneys who are familiar with Wisconsin law and familiar with the prosecutors and the judge, the people involved in the particular case. And then you have, somewhat of a figurehead like this Lynn Wood, who's going to fight the fight where it's equally important these days, and that's in the media and on social media. And unfortunately, that's the way it is. I mean, you've got to fight on all the fronts. And I think that's what his job seems to be. And he had tweeted today that Kyle did not carry a gun across state lines. The gun belonged to his friend, a Wisconsin resident. The gun never left the state of Wisconsin. So that's an interesting fact, because isn't that what the media was saying? And a lot of the commentators are, well, he was only 17. He wasn't allowed to own a gun, and he crossed state lines, and that was, a violation of West Virginia, or not West Virginia, but Wisconsin code, and, whatever. And therefore he was unlawful, blah, 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 blah. Well, if a friend gave it to him, was any law violated? And certainly we get into the rural areas. I mean, kids used to go hunting in the woods, and, you'd loan out guns to, I can remember people handing me guns. I went in the woods by myself at age 9 years old and killed a deer by myself. Well, hell, somebody gave me a firearm to do that. And that was only a 410. But I can remember hunting with an AR-15, a Colt SP1. It's like a 1 in 12 twist barrel AR-15 with a 5-round magazine, which was legal in Florida, and a Colt 3X scope made in Japan, hunting deer. And I used to do that just because I wanted to hunt with a cooler gun, and why not? But we have a history in this country of underage people possessing and using firearms all the time, and that's not necessarily shocking to 80% of us in the country, though it may be shocking to people who live a life of riding in underground tubes and going up and down in these square boxes called elevators all day. Kids used to have, high school kids used to have gun racks in their cars. And we don't necessarily subscribe to the same principles that they do, or the same assumptions. But that, I think, is an important fact, and that it is an important fact, and that's why he tweeted it out. And he inserted the word defamation. So he's warning the media that, again, he nailed CNN for Sandmann. So he's warning them, stop putting out this false narrative, because it's not true that his parents had allowed him to have an AR-15 that he used to travel to this riot to. Like, no, he was provided the AR-15 by a friend. The gun never left the state of Wisconsin. So there's going to be a lot of laws that are going to be avoided there. Another thing that came out today, or that at least I saw today, is this social media confession of one of the guys who was shot. And I'll put this up. Where is it? All right, here he is. This is one of the guys who was shot. That's Gage Grosskreutz. I don't know how the hell you pronounce that, but that was the guy who had his, I wouldn't even call it a bicep, because he obviously doesn't lift, but that's the convicted felon who was in possession of a firearm and had where his bicep should be anyways, some of it blown off. So there he is in the hospital getting treated for that. And this is a social media post by his friend Jacob. And then with that, there was this. And Jacob said in the comment to somebody, so the kid shot Gage as he drew his weapon, and Gage retreated with his gun in hand. I just talked to Gage, too. His only regret was not killing the kid and hesitating to pull the gun before emptying the entire mag into him. Coward. So here we have a statement from Gage via his friend Jacob. So that could be an important development here, because one, if this is true, if Jacob's to be believed, and he is, because there are pictures, for instance, right here, and that's him right there, of him with a pistol in his hand, no doubt. And I showed this last night. Here he is. Some say he was filming, and you'll see this on social media. They'll say it wasn't a gun, it was a camera. No, you look at his hand, that's him standing. The skateboard attacker just got shot in the chest. That's him on the right side, but that's Gage on the left, and he's got two hands up. And that's something that a lot of these guys are taught. Remember, right before they attack you, they'll put both hands up in the air. And I've had this in cases before. They'll put both hands in the air, as so that witnesses can say, or witnesses recall, or pictures might catch that they were saying, hey man, don't shoot, or something like that. And then they attack you after their hands are in the air. But in any event, you can see that his right hand does not have a firearm or a phone in it at that point. And then as he attacks him and gets closer, you see he had pulled a pistol from what I had heard was around the small of the back area he had concealed. And again, he's a convicted felon, and it's a federal felony, probably a state felony as well, for him to possess a pistol. But again, that you won't hear that from the media. You won't hear that from the left as to well, he was in unlawful possession of a firearm, and that wasn't just a misdemeanor, that was a federal felony. And so yeah, you have a felon in possession of a firearm. There he pulls it. And you can see Kyle on the ground, and he doesn't even have yet his rifle pointed at him. You can see that his rifle is pointed. It's still pointed to the left of the screen. And so he hasn't even pointed it where it eventually ends up yet. And yet the Gage has already pulled his pistol, and it really looks like he's about to shoot him in the head. And in a video, a slowed down video I saw earlier, you can really see that Kyle was about to get shot in the head by this guy. But Kyle shot him first, really had tiger-like reflexes. It was pretty impressive. I suppose that's where we end up after generations of video games. This is a meme I created today. This was obviously the video games as I remembered them when I was young, Double Dragon. And it feels like we've come full circle here, that we're living in Double Dragon. But anyways, he told his friend Jacob that he admitted, what did he admit here? He admitted he had a gun, and it looks like he admitted to some sort of intention as far as killing the kid. So it looks like he had intention to empty the entire mag into him. And so his only regret was, one way you could read this is he regretted hesitating. So he took too long to pull his gun. And so you never pull a gun unless you intend to use it, really. And I think it's a reasonable inference that he intended to use his gun. And so this is going to definitely be the strongest case of self-defense. And whether you realize it or not, even police officers are judged really by every pull of the trigger, where you have a delay between shots. You will get judged by every pull of the trigger. So there are a lot of cases out there where even in police shootings, where there's a delay, pow, 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 pow. So all the first string of shots really are judged under the same self-defense analysis standard. And that's what police officers go through, is the same reasonableness standard. I reasonably was in fear of my life or the life of some other person or some other officer. And it's the same standard, really. And so all those shots are judged on the same standard. So if you're authorized, if you're justified in the first shot, you're justified in the next 4. But where you have a delay in between, then potentially you're looking at a completely different analysis for that last shot. And that's always a danger, because you're not allowed to, even if it's a good shoot, somebody has a gun pointed at you, and then now you've shot them 4 times, they're incapacitated laying on the ground. You can't just go up and issue, the final kill shot just to put them out of their misery. No, I mean, you've just murdered somebody now, even though it was a justified self-defense shooting before. So where you have a delay in between shots, or you have a delay of time in between shootings, such as we have here, there are going to be different self-defense analysis for each one of these situations. And this one is the strongest with Gage. And I think that's Gage right there. And he's a felon. And one of them, maybe it was the first one. Here he is. Yeah. This guy was a sex offender, as it turns out. And I thought this was pretty funny. Kenosha rioter allegedly shot in the head by Kyle Rittenhouse as a convicted pedophile. And then this comment, hilarious. He died doing what he loved, chasing minors. And he got the memes he deserved as well. Where is that guy? So here he is. And this is the guy you see on one of the videos. And, you go back and look at the videos and you'll see him. So I mean, basically we have all criminals here. And that's probably a shock to most of you. So on the one hand, here is Kyle Rittenhouse. And from a trial perspective, how good is this? If you could choose which side you want to represent as the attorney, who are you going to pick? The kid that is out there trying to clean up graffiti, American flag on his hat, and he looks up to firefighters and police, and he wants to help his community. Probably has good grades. Maybe his father was a cop. I don't know. His mother's a nurse, I think. Who do you want? Do you want him, or do you want the registered sex offender who was out there trying to destroy property and is caught on video using the N-word, talking like an idiot, and being an all-around criminal? Who do you want to represent? Him or him? And that's important. That's big. And that's a lot of the time what I have to fight against in civil rights cases is sometimes I'm stuck with the him. And then on the other side of the courtroom, there's the police officer who, he beat this guy up, but this is how he comes off in court. And he has all sorts of awards and merit badges, and he comes off like a Boy Scout. And so it's very difficult to convince the jury, look, even though you see a video of this guy beating this guy up, don't feel too sympathetic. You have to follow the law. You have to do what's right. Well, a lot of times, they're just going to rule for this guy. Even though they saw it on video, they don't care. And I even had one case where the federal judge had to take up the jury verdict and throw it out because it was clearly wrong, because he saw the video. So that, optics becomes very important. Jurors are going to tend to rule in favor of who they like. So if you're this kid and you're involved in a self-defense shooting, you're already starting at first base compared to as if you're this guy and you're in a shooting. So, if you're his lawyer, you have some issues to deal with. And here's one of the other guys. This is I don't remember which, this is a guy that got shot in the chest, I guess. He is another criminal. And let's see, here's his rap sheet. Look at this stuff. Felony, second degree, recklessly endangering safety, use of a dangerous weapon, domestic abuse. And I think that means gun. So let's say use of a gun and committing domestic abuse. All right, so domestic violence, basically. Strangulation and suffocation with domestic abuse. False imprisonment, so kidnapping, domestic abuse, that's a felony. Use of a dangerous weapon. So sounds like use of a gun to kidnap, a girlfriend or wife, who knows. Battery, disorderly conduct, use of a dangerous weapon, a gun, I think, disorderly conduct, domestic abuse. So some of these charges dismissed, but he's definitely a convicted felon. Looks like he's also would be a prohibited person for domestic violence. So, the media tries to paint him as, oh, he loved peace and he just wanted to help people. Well, maybe he has a deceiving smile, but why did he plead guilty to strangulation and suffocation of what looks to be a woman and using a gun at the same time, it looks like. So, they won't report him that way. And that's always a component of these self-defense cases, is avoiding that media narrative. There was one self-defense case in West Virginia where I published the entire media narrative from beginning to end. And you can see how the media turned on him, and just every media report got worse and worse, 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 and worse. I'm running out of time here. So militia versus individuals, it was another thing that I had seen that people were talking about. So does it make any difference that, he may have been there with one of these self-professed militia groups? And since the Second Amendment says that the people are allowed to be armed for the militia, does that have any relevance to this case? So in 1791, when the Constitution was ratified, the militia system was how we did it. Everybody between the ages of X, Y, and Z who did not have some good medical excuse was required to be in the militia. You had no choice about it. And you were required to have your own military long rifle. You were required to have your own gunpowder, and however many pounds of gunpowder. You were required to have at least like 60 shots worth of lead. And you had to provide this all your own. So the people were required by law to be armed with military weapons, and that's how our country was created. And if you were so poor that you didn't have the proper guns and ammunition in your house, there was the earliest form of welfare in our country was if you filled out an application that was embarrassing, then you were allowed to borrow the weapons and ammunition from the public store of weapons and ammunition. Even if it was like being entitled to a lawyer. It was like, if you can't afford a lawyer, one's going to be provided to you. Well, if you can't afford a gun, it's like if you can't afford an AR-15 and 60 rounds of ammo and an extra magazine, then one will be provided to you from your local county's arsenal. That's basically how our country was started with the militia system. But fast forward to 2008 and the Heller decision, and the militia, the well-regulated militia part of the Second Amendment itself was discussed, and the Heller majority rejected the proposition that, and they called it the prefatory clause, and the prefatory clause being a well-regulated militia. And they basically said that part of it is really immaterial to why the amendment was included. Yeah, the prefatory clause and the operative clause. So the prefatory clause was the militia part. The operative clause was the important part, that we're allowed to have guns for self-defense reasons or whatever. The operative clause was the important part, that the people shall have the right to keep and bear arms. So the court explained that the operative clause fits perfectly with the prefatory clause, creating the individual right to keep and bear arms. Basically, it consisted of us having self-armed citizens at the time of the ratification. So the people were the militia in the 1790s, and the people were guaranteed the right to keep their own arms in case they needed to fight with them, because the The people were the power because they were the ones with the sword. They were the ones with the gun. That's the way we were designed. But we got away from that. And that's kind of where we've ended up, is that the militia, the prefatory clause, is largely inapplicable to the Second Amendment at this point, at least as the Supreme Court has told us what the Second Amendment is, which is not what it's supposed to be, but we get what we get, or perhaps we get what we deserve in some people's opinion. So that brings me to, lastly, then the state of the law in Wisconsin. And that's not where I practice, obviously, but in federal law, federal civil rights law, mostly what I do, you look at your location. So there are multiple federal circuits, which are the federal appellate courts that decide what the law is, federal law, and they're the next closest thing to the U.S. Supreme Court. So what's the federal law? And Second Amendment is a federal law. So if you're looking at your federal constitutional rights, you want to look at federal law, because that's going to be the law of the land. And the law of the land depends on which circuit you're in. Here in West Virginia, and even Maryland, and North Carolina and South Carolina, we're in the Fourth Circuit. But Wisconsin is part of the Seventh Circuit. So I took a look at some of the important Second Amendment case law out of Wisconsin. And that can be important because you can know, a lot of the same judges are there. You can know how they're going to rule on certain things. And there have been some important Second Amendment cases that came out of the Seventh Circuit, really. And the most recent one is Wilson versus Cook County from 2019. And that was another challenge to the Friedman versus Highland Park case from 2015, which almost went to the United States Supreme Court. But that was a challenge to the assault weapons ban in Chicago and the rest of Cook County. And so the Seventh Circuit declined to overturn the assault weapons ban because they had already declined to do so 5 years earlier, basically. But looking at some of the language, they had discussed, AR-15 style rifles. So, their point is that since our 2015 case in Friedman, every other court of appeals, federal court of appeals, to have considered the constitutionality of so-called assault weapon bans and large capacity magazine bans have decided that they don't violate the Second Amendment. So they did not overturn this ban, finding that you have the right to have an AR-15, unfortunately. And that almost went up to the Supreme Court. And I believe that Justices Scalia and Thomas really had voted to overturn the Chicago's assault weapon ban, or Highland Park's ban rather, from 2015, and that the rest of the court voted not to. And they were, really our most pro Second Amendment justices, but they weren't enough votes to get that. Had they been enough votes, and that's why the appointment of Supreme Court justices is very important. Had they had enough votes, we could have a Supreme Court decision here today that says the Second Amendment protects the right for all American citizens to own a AR-15 style rifle, which the court noted in the Seventh Circuit, going back to them, they noted that a lot of Americans have AR-15 style rifles, and that there's a logical reason. If the Second Amendment, if the point is to be able to defend ourselves, which it is, then it makes sense that people own AR-15 style rifles. And if you go back to the next case, Friedman versus Highland Park from 2015, this is actually what the court discussed. Is they said, the features prohibited by Highland Park's assault weapon ban were not common in 1791. Most guns were available. Then they couldn't fire more than one shot without being reloaded. Revolvers with rotating cylinders weren't widely available yet until the early 19th century. Semi-automatic guns and large capacity magazines are more recent developments. And there's some disagreement with this, but they go on and, they get into history. And they're ignorant about a lot of it. They're wrong about a lot of it. But they went on, though they said, and this is the one helpful thing they said, is true enough, assault weapons can be so-called assault weapons. We all know that under federal law, assault weapons are machine guns. AR-15s that are semi-automatic are not assault weapons under the federal government's own laws and regulations. So in any event, this is what the court said. True enough, assault weapons can be beneficial for self-defense because they are lighter than many rifles and less dangerous per shot than large caliber pistols or revolvers. Householders too frightened or too infirm to aim carefully may be able to wield them more effectively than the pistols James Bond preferred. So that is a Seventh Circuit case. That's part of their holding, part of their case law. And although they declined to overturn this assault weapon ban, that is a good point, and that's always going to be a good point, is that, well, the so-called AR-15s were created because you can put them in the hands of a 17-year-old, because that's largely what we sent to Vietnam when they first were issued to the military. You can put them in the hands of a 12-year-old, of a small female, and they have 30 rounds that they can very accurately put on a target with very little recoil. It's very accurate, and up to several hundred yards. I mean, you try hitting something with a pistol several hundred yards away. It's almost impossible for a skilled, large male to do. But you can almost give anybody with very little instruction an AR-15 style rifle. It's very lightweight, very easy to operate once you know how to use it. And an elderly lady could hold off a gang of armed attackers theoretically with an AR-15 style rifle. So if the purpose of the Second Amendment, we all agree, or the courts agree, is to be able to defend yourself, or at least to defend your home, is as far as they've extended it, then why not have something more effective than less effective? And that's a very, very good point. If an elderly lady, she's going to have a problem shooting a .357 Magnum revolver. She's going to have a problem operating a Glock semi-automatic pistol, that actually takes a lot of skill and takes some muscle to properly use the action on it. So if you're an elderly person, you have arthritis, maybe that's almost impossible to do. Maybe you have a 30-round magazine or even a 60-round magazine and an AR-15 ready to go, and if you have a problem, you're pretty much set to deal with it. You're going to be able to defend yourself. So the Seventh Circuit Court, that is part of their case law, and that is one aspect that could be helpful, is that they have acknowledged the role that AR-15 style rifles can play in self-defense. And that's really going one better than we have here in the Fourth Circuit, where they, through their Colby case, and they have villainized really AR-15 style rifles as just a tool of the madman, of the mass murderer. So it could be worse. But so there is some discussion in those two cases of the AR-15 style rifles, and there's more, but you can read those cases to go through them. Lastly, I'll contrast that with the case that was just issued out of the Ninth Circuit, and I've discussed before, the Duncan versus Becerra case, and it just came out a few weeks back in the Ninth Circuit, which was a surprise because that's the California circuit, Hawaii circuit, and they found, or at least three of their judges found, the panel found, that there was a Second Amendment right, or is a Second Amendment right, to own so-called large capacity magazines, and that they're protected by the Second Amendment. And now we go back through history, and the court went through the history that it's been a part of our history. And I love the way they wrote this, and I put it up on our website, or my website rather, where is it, civilrightslawyer.com. But they go through this history, and they go through semi-automatic and multi-shot firearms were not novel or unforeseen inventions to the founders of our country. As the first firearm that could fire more than 10 rounds without reloading was invented around 1580. Rapid fire guns like the famous buckle gun, patented as early as 1718 in London. British soldiers were issued magazine-fed repeaters as early as 1658. As a predecessor to modern revolvers, the pepperbox pistol design predates the American Revolution nearly 100 years, with common variants carrying 5 to 7 shots at the ready, with several European variants to shoot 18 to 24 shots. I'll skip a little bit. After the American Revolution, the record shows that the new firearm designs proliferated throughout the states and few restrictions were enacted on firing capacities. The Girandoni air rifle, developed in 1779, had a 22-round capacity and was famously carried on the Lewis and Clark expedition. So I mentioned, I don't remember which live cast it was, that I actually shot the only existing version of a Girandoni air rifle that exists on this earth. And it was brought right here to this office, and I shot it in the basement. And it's a long story, but the guy who discovered the original Girandoni air rifle that was carried by Lewis and Clark, that's now in the U.S. Army's museum, he got to create the bench copy to it, and he brought it to my office for another reason, but I had never heard of it. So he brought it here and he showed it to me, and it was absolutely unbelievable. We shot it in the basement, and it indeed did hold like 22 shots. And I have here some of the lead balls that I actually kept that were shot in my basement. And here's one that's mostly unshot. You can see, well, it was shot. It's maybe 40 caliber or so, just a lead round ball, which the flintlocks at the time would shoot. And you can see this particular version, look how it's flattened. I don't know if you can see that, but it was a lead round ball. It's completely flattened, just like it was shot out of a regular flintlock musket or rifle. I mean, that's the force that this thing shot. And 22 rounds, you just pull the trigger because it's pre-pumped. You pull it to the side and you click a lever and it drops the next one in. It had a feeding tube. So you could shoot, click, shoot, click, shoot. And these are, shots that ran through that actual gun. So stuff like that was around. It was known to our founding fathers. They also mentioned a pepperbox pistol. And I've got one right here. This is a pepperbox pistol. You can see it's instead of having a revolving cylinder that puts new rounds into the barrel, it's just got revolving barrels. Thing's pretty badass looking, and even if it didn't work very well or wasn't very accurate, sure as hell whoever you're pointing it at. So pistols were always close self-defense weapons, but this is a pepperbox pistol. And there are different variants of it, but this is kind of what they're referring to as a pepperbox pistol. In the history of the United States, I mean, it coincides with the history of firearm development. And that's what we were all about, is developing new firearms and new technologies. And as we moved west, the new firearm technologies moved with us. And it's really a part of our history. So I'm sure I'm wanted at home, and it's Friday evening, and I've gone through most of what I wanted to talk about. I think I've put up most of what I wanted to talk about. I see there's lots of comments I didn't really get to. Militia Man, love your firearm collection. Well, I appreciate that. I could talk all day just about guns. Need a Thompson. All right. What was the next one? You need a Thompson on your desk back behind you. Well, somewhere I have a picture of me shooting a real Thompson, a real full automatic Thompson when I was a kid. And I'll tell you what, the thing that sticks out in my head from the real Thompsons were that, they had the wooden buttstock that was super heavy. I just remember that as a kid, like the damn thing. I mean, it's so butt heavy this thing. It's like real light out here, and then it's just like super damn heavy in the buttstock. And it's pretty slow as far as machine guns go. So it's like 600 rounds per minute. So instead of like, it was like, it was like on the lower end of machine gun speeds. But certainly Thompsons are, I mean, that's pure America. And you know, I'd love to have one. I really would love to have one. But I don't have one now. And I mean, there's a lot of stuff that I want that I have to have priorities. Let's see. Genius of the United States Constitution. When it frustrates the government, you know it's working. Yep, that's absolutely right. Second Amendment case goes to the High Court. The High Court will affirm the people's right to own and carry a gun. I mean, the Supreme Court really has only applied the Second Amendment in your home and with a handgun. So it's going to have to come up again. So it's really important that Second Amendment friendly justices get put on the Supreme Court. But here's the other thing is that the Fourth Amendment is also very important because since the Second Amendment hasn't been extended very far, really the Fourth Amendment in practice protects most of the Second Amendment rights. So I'd like to see judges or justices appointed to all federal courts who across the board are liberal in their interpretation of the Constitution as it was written. And I don't know that that's a specific ideology, but I would like to see justices who across the board support individual rights as our founders intended rather than support the government or support the police, because that was the problem with Scalia. He supported the Second Amendment, the citizens when it came to the Second Amendment, but then he'll support the police on every Fourth Amendment case. So I would like to see it across the board, justices who support just the intention of our founders of individual freedom and smaller and lesser and a less restrictive state and federal government. Bukhara just challenged it to the 9th today. I knew that they were going to try to have a rehearing en banc, which is before the entire circuit, and so it wasn't over on that one. So maybe that occurred. I haven't seen that. So, but it was expected. So hopefully that follows through. Let's see what else. Will Kyle walk on all charges? If not, which charges will he be convicted on? Well, you just have to rewind the video and watch the whole thing again. You know, who knows? Nobody knows. There's nobody on this earth that knows. It depends. You know, there are so many laws available to prosecutors. Like I said, there's 5,000 federal laws alone when there was only, like 16 or 18 or maybe less in 1791. It was like treason, murder. There were a couple others. Now, I mean, you everything is a felony, a federal felony, and that's not even including the state charges. So everything's illegal. That's what our government has done. Everything's illegal. So the possibility of getting out of anything and everything, I mean, maybe they get them on firearm possession. We'll see. But I'll leave that to the lawyers in Wisconsin. The important thing are the murder charges, and that's what's going to be important that he walks on. So if the jury's given the opportunity to give him some stupid Wisconsin misdemeanor, but give him not guilty on the important charges, then that would be a win. That would be a big win. Let's see. Bill Connolly, you respect and support much of what you do. Need more lawyers just like you. Yep, I appreciate that, Bill. There are a lot of lawyers out there that do a lot of hard work in the trenches every day, but you just don't know who they are. And part of one of the reasons why I started my newest Facebook page, Freedom is Scary, is because I wanted to be able to have a resource for people who are, like-minded lawyers and other people, or just researchers who want to help with a lot of these cases and feel the same way, so that they can communicate and touch base with each other. And part of all this COVID-19 stuff, one of the lights at the end of the tunnel is I've met so many other lawyers who feel the same way that I do at fighting in, say, in their state, the way I've been fighting in my state. And so we've been able to coordinate and get to know each other, and not just lawyers, but others and legislators. And so I think that's going to be able to be brought to bear in other types of situations, such as kind of what we're seeing here in this crisis of government allowing rioting mobs to destroy property and potentially kill us and our families. We need to take the necessary steps to take our freedom back, to be able to defend our property, defend each other, defend our families. Let's see. Cops allowed the contamination of the crime scene when unknown person picks up the bicep dude's handgun and manipulated it. Henry, I didn't see that. And I think you could spend all day, every day, and some people do, just poring over these videos and doing different factual analysis of what this video showed. And there's a puff of smoke here. There's a gunshot that came from here potentially. And this guy said this, or did he say that? There's going to be a lot of that. And that's what this kid's lawyers are really going to need to do. And there's no doubt there'll be a lot of experts involved. And I think if you're the defendant, you hit with anything and everything you got. And if there's contamination of the crime scene, some unknown person picked it up, then that you have to use that to your advantage. So the one, really, for better or worse, that's the way things are now, is everything's on video, and there's video from different points of view, and video is important. But video also can be deceiving. So especially when it's at night. Henry, look for the video where victim one shouting, "Shoot me N-word." Yeah, I saw that video. You see the man with a firearm right before V1 starts shouting, "Shouting, shoot me." Yeah, I did see that. I know you're talking to Henry, but I'm surprised he wasn't arrested for having a gun, being a felon. I don't know that he wasn't, but are you really surprised? I read the actual complaint charges, the complaint document with the criminal charges, and it looks like, as a female prosecutor, career prosecutor, I looked her up, and I mean, I have nothing critical to say, but she's a prosecutor, and people hate the police in this country. Well, the police they're doing their job, and I've been as critical of police as any lawyer out there, and that's what I do for a living. But you want to really see who's filling up the prisons with people, putting people in cages. You take a look at the prosecutors, and I can't sue them generally. You can't sue them; they have absolute immunity. You want to talk about qualified immunity? That's nothing. How about absolute immunity? That's what judges and prosecutors have. And the prosecutors have the real power to decide what people are going to be charged with. They have all the tools at their disposal to put people in prison. People like Kamala Harris. Look at all the people. Look at all the black men that she's put in prison over the years. I wonder how many there are. That is the real scary thing. I'm not worried about a conspiracy of racist police officers all across the country. I'll look at it on a case-by-case basis. Everybody's potentially capable of being a bad apple, of having their own prejudices. But you want to look at an unjust system. Look at the system of the conviction machine, I call it. You try a murder case, and you'll see the list of witnesses they bring down. The medical examiners, who are nothing but whores for the government. say whatever the government wants them to say. You've got blood spatter experts. You've got, this expert and that expert. It means nothing. They're all just a component, a cog in the wheel of just one big machine designed to put people in prison. It's almost impossible to counter it, to defend yourself against it. It's almost impossible, even if you have money. So, a lot of this is a red herring. Let's look at the prosecutors. Let's look at the entire society we've created of criminal laws, of criminalization, over criminalization of absolutely everything. Everything is a crime. And look, they can even do it to the president of the United States. And look at Carter Page. Look at Roger Stone. They can do it to anybody. They can go after anybody. They can lock up anybody, just about anybody. I think Trump would be in prison if they got their way. But they're not far from having that sort of power. And there's stuff like has happened here with this Kyle Rittenhouse, not on that scale, but all over the country, and you don't even know about it. And there's just been like one appointed lawyer down there in the trenches working for the kid, hopefully. So it's about the society that we've created, the over criminalization of everything. Because why? Freedom is scary. Because our forefathers, at some point, our fathers, our grandfathers, our great-grandfathers, they got to be old men. And then what happened? A lot of times they got scared. It's like an old couple. They cut all the damn trees down around their house, the beautiful trees that provide the shade for their house, because they start to get paranoid as they get older. The damn tree's going to fall in their house. And so they cut the trees down. And so that's what a lot of our fathers and grandfathers have done, is they start to get scared. So they've made every damn thing illegal. Everything's illegal. And possession laws, and this is a whole different video, but possession laws, do you think those were a part of our society in 1791 when our country was really created, our Constitution was ratified? No, they weren't even part of the English common law that we created our country out of. Where did the concept of making it illegal to possess anything, especially like an idea or something, but say a plant, and I have no interest in smoking pot, never have, but let's say the concept of it. Do you think George Washington or Thomas Jefferson or James Monroe or James Madison, do you think they would have ever thought that in the country they were creating that it would be illegal for one of its citizens to possess some certain sort of plant, or to maybe cross a state line or something with a plant? That concept was completely foreign to them. Where did that concept come from? Do you want to know where it came from? It came from Sharia law and authoritarian Far East regimes. That's where it came from. It was not a part of the English common law. In fact, there was no such law, even England, if I recall correctly, until like the mid 19th century. And the very first, we want to talk about prejudice, bigotry, racism. The very first possession law in the United States, I believe, had to do with California and suppressing the rights of the Chinese immigrants because they enjoyed their opium. They had opium dens, and they made it illegal to possess opium. And that was our very first possession law. I believe that was in the late 1870s, maybe 1880, somewhere around there. It was post-Civil War in any event. So during the entire time of our founding fathers, of the Jacksonian era, of the pre-Civil War era, of the Civil War era, it was not illegal. It was not even a thing to make it illegal to possess something. Now, look at all the things we can't possess. Hell, no one lawyer or judge would be able to tell you all the damn things that are illegal to possess. And we brought that into our law from Sharia law. And we've allowed the creation of this police state, the over criminalization of our society. And look what it has resulted in prisons all over our country, where we keep people in cages. And I don't know what the answer is, but I don't know. There's no way that is something that was planned out or foreseen by our founding fathers. And again, that's for a different talk. But I appreciate you watching. I know there's more comments than really I have time to get to, but I'll go back through some of these comments on Facebook and in YouTube where this is broadcasted and answer some of these questions after I have my whiskey and my cigar, because it's Friday night and I've been working all day, and I still made time to rant about the Kenosha shooting and got through all of this stuff. And I appreciate you watching. And so this was episode 9 of what I'm calling Freedom is Scary. And I think that's an important phrase. And if you feel like I do, and you think the same way that I do, that the concept of liberty, even if it's scary to the Karens around us, it needs to be preserved, and that it needs to be argued in specific cases like what happened in Wisconsin, and then certain cases that I encounter here in West Virginia, and there's different cases in Florida. Then we need to have communication. And although things like Facebook and other tech giants really want to censor us, until we have no other choice, we have to use these tools to our benefit, and we have to use it against them. So like my Facebook page that I created for this specific reason, Freedom is Scary. So check that out on Facebook, and there's a private group, and follow the page, and you should get an automatic entry into the private group. If not, hopefully I'll send you an invite. And until then, I appreciate your watching and your assistance, your comments, and obviously that I could go on all night long. Hell, it's been almost 2 hours, and it's like that when you try a case. When you care passionately about something, when you're trying to save some kid's life, or even when you're trying to make a legal point. I mean, hell, when you know every little thing about something, or you care that much about it, I mean, hell, you can sit there and you could talk to a jury for 6 hours straight. I mean, it might feel like it's been 30 minutes, but I mean, meanwhile, it's 6 hours later. And you have to avoid stuff like that because not everybody feels the way that you do. But that's that is the breadth of the issue. I mean, that's how complicated it is. I mean, hell, that's why reading articles really is a lot more efficient than watching YouTube videos, because someone can only say so much in 2 hours, whereas somebody can read in 20 minutes enough that I could say in 6 hours. Bruce Bartell. No one needs an assault weapon, and militiamen need to join the army if they want to play soldiers. Well, Bruce, I'm not taking the bait. Bruce is a former client of mine, but he's from New York, and so he's got the derangement syndrome really bad. But one day I'll get him to come around. So I appreciate you joining me, Bruce. But we'll talk to you later, and I appreciate you watching. And make sure to follow along and watch next time, both on YouTube and on Facebook. And I have some important cases coming up that I'm getting ready to file. So if you haven't liked my Facebook page, you might want to like it, because there's some big cases coming up that I've been working on behind the scenes. So until next time, let's see, let me turn this thing off, because I'm my own producer here. Until next time, thanks for watching. And let's see, we'll see you later.
Hey, listen, people, I'd like to say, 1,000,000 minds have a choice of ages to articulate. So when it's